everyone. Thank you for joining us today. For those of you who are new to this group or new to World Law Group, I am Hannah Shea with World Law Group, and I work with our 15 practice and industry groups. This being one of them, this meeting is hosted by the technology group, which was previously known as artificial intelligence, but we made some changes recently in our practice group and committee and forum refresh, this group being one of those changes, now the technology group. So welcome and thank you all for joining us today. Just a few quick notes before I hand it over to our leaders. This meeting is being recorded, and you'll see the Otter AI at the top. That's our note-taking service, so that it helps us put recaps together a little more efficiently and quickly. So it is being recorded, and we'll have it on the website next week. With that, I'm going to ask everyone to, before we get started, if you could hover over your video and click on the 3 dots at the top to rename yourself and include your firm, we'd really appreciate it. And if you have any issues doing that, just send me a private chat. I would be happy to do that for you. If you do have any questions at any time, or you want to chime in on the conversation, we encourage you to do so. So please turn your video on if that's possible for you to do. And you can use the raise hand feature if you know how to use that, or just chime in if you have any questions. With that, I'm going to hand it over to Peter and Chung, 2 of our 3 co-chairs of this group, to get us rolling.
Thanks very much, Hannah. It's good to see everybody, wherever you are, morning or evening today. So we're going to really do 3 things today. One is we're going to take a few minutes at the beginning for everybody to go around and introduce themselves, since this is a revamped committee with people having moved around, some who are in IP, some were in AI, some in other areas, to make sure we all know each other. The second is we're going to have a little bit of a discussion after a few initial comments from Chung, really about contract drafting to deal with AI, all kinds of different contract drafting, as we move into this era of uncertainty. And then the third thing is maybe talk about for a minute what else we can do next as a committee that might be of interest to the group. Just to start, my name is Peter Ruby. I'm with the Goodman's law firm. And my practice is almost entirely dealing with arbitration and litigation matters related to technology in one sort of another. And one other role that's maybe worth mentioning is I'm also the current president of the International Technology Law Association. I recognize some of you from there, and hope that you'll be able to join us in Amsterdam. And maybe at the end, we can talk about if there's enough of a group that we could try and organize a little breakfast or meeting to get together. Chung, do you want to introduce yourself?
Thanks, Peter, and good morning, good afternoon, good evening, everyone. Great to see all of you, and thanks for taking time. As Peter mentioned, the 2 of us, we're co-chairing the technology, the revamped version of the technology group. So I'm based in Asia. I'm based in Singapore. I head up the IP-TMT practice at Wong Partnership. I kind of do a little bit more of a wider mix. I'm not just purely handling litigation matters, but I also happen to handle corporate transactional IP and technology related matters as well. On top of that, I do dabble in mediations and arbitrations that relate to IP and technology. So glad to see all of you, and also hope to build on the networks that we have, and to be able to work with all of you. Maybe I'll just nominate because it's so difficult in a Zoom kind of a setup. Benedict?
Yes, hello everybody. I'm Benedict from Munich, Taylor Wessing. I'm leading our firm's practice area, commercial agreements and distribution. So it's a broad area covering all kinds of commercial agreements, and I'm mostly helping international clients entering the European or German markets. And what I just joined this meeting because, first of all, I'm still kind of new to the World Law Group, so I'm looking forward to seeing many of you in Rome soon. And I think we have to deal with tech. We have somehow it's all around us, and we need to know what's going on and how we can use it in order to enhance our businesses. So maybe next, the ladies, Janet.
Hi, I'm Janet. I'm from Malaysia. I co-head the telecommunication media technology practice group in my firm, and I'm also a partner of our intellectual property department. I think being such a wide practice area, I think it's I think I think it's safe to say that the practice covers a wide area. And I suppose a large part of my practice also focuses on data protection and privacy. And yeah, it's a very exciting time now. And I look forward to getting to know everyone in the committee. Thank you. With that, I will nominate Sergio.
Hi, good morning, everyone. My name is Sergio. I am from Urenda and Correo Regoteur from Santiago de Chile. I am basically concentrate my practice in corporate contracts and natural resources. And my primary interest is to learn about this matter. I think it's something that is nowadays very strong and will just starting in this area. So I basically want to hear and listen from all of you guys.
Anyone want to volunteer to go next? If not, maybe Alain.
Fine with me. Alain Remy from CMS in Switzerland. I'm M&A lawyer, doing corporate M&A. Have a certain expertise in tech deals and have been the partner responsible for our IT department on the firm side during a couple of years. And therefore, I'm also interested in knowing new tools or new software that can be used also in the practice of contract drafting. I'm here to listen and to learn. We're not yet using any AI-based tools in this respect, so I'm curious to learn.
Great. The problem with this is remembering who hasn't gone yet. So please feel free to jump in. I know no one on this call's shy.
I can jump. This is Alejandro Negro from Cuatro Casas. I'm based in Madrid, in Spain. I'm an IP and IT lawyer, okay, dealing mainly with all kind of technology matters, both litigation and transactions. And right now, in particular, I'm leading the privacy matters in Cuatro Casas. We are using in Cuatro Casas Harvey but we started last week. So I'm just playing with this kind of technology. So I cannot explain you a lot in this moment. I wanted to spend a couple of days just trying and checking and proving the technology, but honestly, I didn't have time. So I'm also here just to learn what are you doing right now with all this kind of artificial intelligence.
Maybe
Next one.
Yeah.
Hi everyone. This is Gautam Rego. I'm a partner at AZB and Partners in Bangalore, India. So my practice areas include corporate M&A transactions and information technology and data privacy. So like some of the others mentioned, we aren't using any of these tools currently as well, although I have played around with them to some extent, but happy to hear from everyone and looking forward to learn.
Okay, maybe I can start now. Mikołaj Sawiński from Poland, SKS law firm. I'm heading a TMT team in our office. We mainly work for software companies, for media companies, and I hope that you can hear me well. I'm actually right now on the conference for software houses where I will be speaking about new regulations on artificial intelligence. So right timing. Thank you.
Right.
I can go next.
I am Sandhya Iyer from Vesh Associates India, and I handle banking and finance and insolvency, and I do a little amount, some amount of corporate work as well. We do not use AI in contract drafting, at least at present, and yeah, would be very, very interested in learning how others use it.
All right, I'll proceed. Torsten Torbe from Bækbrun in Copenhagen, Denmark. Yeah, so my area is legal tech. So I'm heading our division for our department for legal tech and innovation within Bækbrun, and has done so for the past 5 years. Yeah, we are using contract drafting in various ways, but not today with the connection of AI.
That's great. Is there anybody who's not had a chance to introduce themselves?
Yes, me. Hello, good morning. My name is Veronica Roa. I work for Urenda, and I see a lot of corporate things and mining issues and some data protection as well. So that's my interest in participating in the group and getting to learn and take advantage of the more experience that other lawyers may have in this matter, because for us it's still kind of new here.
Great. I think that was
I could go next.
Oh, sorry.
Yes, hi, I'm Tanya Dorian from Davies in Montreal. I am the KM and Library Director, and I'm in charge of basically helping bring in a lot of innovation, including AI. We are using some AI tools and are in the market for others. And amongst this, we're also working very close with the privacy group, as well as our IT team, and just making sure that whatever we learn in terms of the business of law and AI can also be transferred to our clients when appropriate as well.
Great.
So hoping to learn a lot from this team.
And my name is Zafer Yılmaz. I'm from Hergüner, based in Istanbul, Turkey. I mainly work on corporate and M&A law, but in the last few years, I've been personally very interested in legal tech and contract automation tools. And also recently, we've been approached by some local tech firms about the possible use of AI in law, which was a surprise to us because we didn't expect the market to be that evolved yet. So like many of you, I'm here to learn more about those AI tools.
Hi, joining also Jeff Jefferson with Locklord in Boston. And I'm in the corporate practice group doing M&A and private equity. And I am looking forward to AI doing the first draft of a merger agreement in the near future. So not looking forward to it negotiating the entire deal, but at least the first draft.
Terrific. Anybody we missed?
Yeah, I'm Esco. I'm from VLOF in Vietnam. Right now, we're not actively using AI for drafting, but potentially in the future. So kind of looking at options now. AI here is kind of maybe a little bit sensitive, which is kind of interesting. I think that kind of sets us apart from other places in the world in this way, because there's a political aspect to it in some ways. And so I'm interested to see what other people have to say and what the experiences are from other jurisdictions.
So thank you, everybody. It's clear from the descriptions everybody gave that two things at least jumped out at me. One is that we have a huge variety of experiences here that we can draw on: commercial drafting, M&A, some litigation, IP, technology, data. So this group has it all in many ways, which is completely necessary to talk about AI. The second thing that jumps out at me is we should really do a session, not today, so people have a chance to prepare on what their firms are doing to use AI internally and whether they find it's a good idea, it's being helpful, and so on. So maybe we'll, Chung, organize a session on that for another day. But it seems like there's a lot of interest in sort of that kind of inside topic. Today, what we're going to do as a topic here is, and hopefully you can see the slides, is we're really going to talk about contracting, and really in one particular area, which is not to have AI systems do the drafting for us, but really deal with the problem that we can see that AI is becoming more and more involved in many of the businesses that we deal with, whether it's on the M&A side or commercial drafting. And so the question that's come up is, how do you future-proof your agreements a little bit when we know that there are AI-specific laws either just being enacted, recently enacted, or in some jurisdictions we can see them on the horizon, but they haven't yet arrived. In other words, this is an area of tremendous uncertainty. So how do we protect our clients and help them protect themselves by using words in the contract that take into account the fact that we don't know what's coming with a great deal of specificity on a huge variety of topics. And really, I know a lot of you came on and said, you're here to learn. Chung and I would say exactly the same thing. So what the plan is really is Chung's going to use Singapore as a bit of an example to try and talk about essentially what some of the areas are where there's some uncertainty related to AI and where AI laws may change what we do. And then we're going to just try and together go through some topics, and I hope everybody participates to talk about creative ideas we all have for how to draft to take into account that suddenly there are all these new areas that we need to cover off, risks we have to deal with, when the risks themselves and the nature of the risks are often unknown and are new. So that's the plan for today. So Chung, do you want to start a little?
Sure. So thanks for that introduction, Peter. So as Peter indicated, probably a good place to start as we think about the issues is to kind of figure out, what kinds of regulatory approaches have kind of emerged. For sure, the conversation is developing. And of course, I think, generative AI in particular kind of just came into the limelight last November when out of the blue, a lot of people were taken by surprise when we suddenly had tools like ChatGPT changing the paradigm, as it were, right? So basically, instead of people having to Google for an answer and then to plow through a whole bunch of results that come out from a search, the promise of generative AI be that you're able to pose a question and get an answer, which nicely presents, a consolidation of all of the stuff that is out there, which purportedly answers the question, and thereby saves us a heck of a lot of time and puts jobs at risk, I guess, especially if you're a junior lawyer just starting out. So that's where I guess the trend line is going. But what are indeed some of the regulatory issues that we need to be thinking about? What are some of the regulatory or legal kinds of challenges that this new paradigm is going to pose? So I guess I'm just going to kind of survey, as Peter says, share some perspectives from Singapore angle, but I think, it's also good for us to kind of understand what's happening in your side of the world as well. So in broad terms, I would have thought a good starting point to start thinking about the issues would be where the data that is used by some of these generative models relates to personal data. Then, of course, clearly, data protection laws come to the fore. And, I think when we think about generative AI, there's a process whereby basically these the engines that handle large language models. What is happening in the background is that these large language models are tokenizing or working out some kind of correlationships between data. And so therefore, there's a huge dependency on establishing a very wide or large data lake or a pool of data whereby connections can be found between concepts and based on correlations, based on the frequency with which certain types of words might be associated with each other. And therefore, obviously, if there's going to be a collection of personal data being ingested into those data lakes, then personal data protection laws are going to be really important. So the starting point, I think this is also common in many jurisdictions, is that you need to find a legal basis to process that data and to ingest data. And consent is very often that legal basis that can be used. At the same time, a lot of data scientists, as we think about trying to assemble these collections of data or the data lakes, they may say, okay, let's take the position then that if we can remove the identifiability of that personal data, then we work around the data protection requirements. So if you are able to aggregate or you're able to anonymize that data, then it's no more personal data. And because it is no more personal data, then it falls outside the ambit of data protection regulation. But I guess it's interesting to then think about what the tests might be in relation to figuring out if the data has been properly de-anonymized, to properly anonymize or de-identified. Because the approach, for example, that Singapore regulators have taken is that you've got to apply a motivated intruder test. It's not just about removing the name elements or the identity elements in the data, but you have to go further and ask if a motivated intruder who is really determined to try and find out the identity of this person, even if ostensibly the data has been anonymized or aggregated, whether it's in fact still possible to figure out who that person is. So that's one issue. On the next slide, we also have certain exceptions that might be useful from a data science perspective. So we've got the business improvement exception, where if a business is seeking to improve or enhance products or new goods and services, then you don't need to get consent. This was something which was put in place with a view to making things a little bit more flexible for businesses to make use of personal data types of records, carry out business analytics to improve products and services. But unfortunately, when you then seek to try and rely on this to market to people, for example, then you would still need consent. Research exception is also something that's been built into our data protection laws, where again, you do not need to rely on consent or some other legal basis if you're going to be carrying out some forms of research. So data protection is one part. Another part that we probably ought to be thinking about then more generically in relation to data that's not necessarily personal data, then is the whole IP protection framework. So copyright is probably the most obvious area of law that would be relevant. Copyright infringement, of course, can potentially arise, again, from that data lake perspective, where you have compilations of data, where perhaps there might be copyright recognized in connection with the selection or arrangement, or even in some jurisdictions, then the amount of sweat equity or the amount of effort that was put in to assembling the collection of data. So there is a risk of copyright infringement as you assemble these data aggregates. But interestingly, our Copyright Act, when it was amended in 2021, introduced this idea of computational data analysis being a form of an exemption to copyright infringement liability. So if there is lawful access to a copy, then one can carry out computational data analysis. Presumably, all of what I was talking about that goes on in these generative AI engines, or where there's tokenization or analytics going on to identify correlations of data. All of that kind of activity is now permitted under the copyright infringement exception that I was just talking about. But when you actually then seek to make use of these analysis, then that's when you would need to then get the permission of the copyright owner. There is also then the fair use exception. Of course, you would have seen that there have been quite a few developments on fair use treatment and transformative use principles coming out of the US courts. And I'm quite sure some of the colleagues from the US might be able to comment on that. But again, that's one potential area where perhaps copyright infringement, you might have the ability to invoke some exceptions. Then, of course, common law confidentiality obligations, that's another set of issues that we need to be thinking about.
Is Chung's sound off for anyone else?
Yes, here too.
Okay, Chung, you are
Same here.
a little bit. Do you want to try turning your video off? And see if that helps.
Is this better?
Yes.
Better, yes.
Okay, right. So sorry about that. I was just saying that many of you have interest in legal practice management, and when we have been equally considering the adoption of some of these new technologies, one of the big issues that we're facing is how do we make sure that our client data, which is of course obviously confidential, privileged, doesn't get ingested into some kind of huge data library that one of these large language models is maintaining in the back end. So confidentiality is a real issue, and of course in our case, we on top of that we would have legal professional conduct kinds of obligations that we need to be thinking about. Maybe the next slide, just to share on the AI side of things, there has also been, I think, we're in a state of things where the norms as to regulation are not quite clear, but they're still being figured out. But what we have in 2023 is a new AI Verify framework, which kind of builds upon the work that various international organizations have been working off on the issue of AI regulation. And I think it's useful for us to be thinking about these principles, because even as the norms haven't quite clearly settled, they are probably going to give us some indication of where the law is going to be headed. So the 5 principles that have been identified are on the right side of the blocks on the right side of the slide. Transparency in the use of AI systems. How exactly are these AI systems doing or producing the kinds of results that they produce? Understanding how AI models reach decisions. Again, that's very often a black box kind of an issue, concern. Safety and resilience. What sorts of AI decisions are being made, and how are those AI solutions being deployed? So are they being deployed in high-risk environments, or in circumstances where the concerns wouldn't be so great? What about things like fairness and unintended discrimination? What are the ways in which the deployment of these AI models is being thought about to mitigate some of these risks? And then management and oversight, and this idea that humans being in the loop or out of the loop, these are approaches to the adoption of AI and some of the norms that are emerging or at least being discussed are in fact quite focused on aspects of these things. There is also the next slide on the governance of AI models. This is from the Privacy Commission in Singapore. They also have highlighted a bunch of these governance frameworks that we ought to be thinking about in the deployment of AI solutions. So it's about explainability, transparency, and fairness, pretty much similar themes. AI systems being human-centric, and then establishing internal governance structures and measures, determining the amount of human involvement, operations management, minimizing bias in data and models that are being deployed, and then stakeholder interaction and communication. And I guess I just quickly round off by talking about the AI Act in the EU. Many of the colleagues here, I'm sure you'd be better placed to be contributing on this topic. But as I understand it, there is some serious work underway, and the approach that is being taken is to classify AI systems into different levels of risk. Some unacceptable risk scenarios, AI systems, the deployment of AI systems would be banned completely. Examples where there might be threats to people, social scoring, cognitive behavioral manipulation. And then there'll be other situations where it would be high risk, in which case you need to do some kind of assessment and life cycle monitoring. And then the third category, limited risk deployment situations, in which case, there would still be disclosure and transparency. So that's kind of the broad overview. I hand things back over to Peter to maybe start the discussion going on contract drafting impacts of this regulatory framework that we have.
That's great. Thank you, Chung. And I think all of us would recognize that although Singapore, like every jurisdiction, has its own idiosyncrasies about how it deals with data and AI and other topics, IP, there are a lot of common themes around the world. And so, especially in an area where we're all dealing with very multinational practices in the first place, one of the questions is, well, to deal with some of those common elements, how do we draft to deal with the uncertainties, whether it's commercial agreements and so on? I mean, we all know the, compliance with laws representation, but in many areas we've departed from just having one sentence that tries to deal with everything and have very robust provisions about privacy sometimes about open source software. So I thought what we could do is just walk through together, if people have ideas about how to help our clients contract to take into account risks that are not entirely clear yet. So for example, many AI draft laws or already passed laws require some kind of disclosure or description or explanation to users of what the technology does, how it makes its decisions, where it gets its data from, things like that. So the question really, maybe we'll start with for the group, is at what level of detail, given that we don't know what the requirements are worldwide, and we're often faced with contracting from multiple places, how do you draft to deal with that risk, where you want to make sure that the people your clients do business with are actually complying with the description and explanation requirements that seem to be coming along?
Maybe I will have a comment on that. I'm sorry, I will have to be leaving soon because my speech is approaching, but I just wanted to say a few words, and I count on further meetings on that. I think that at this stage, at least in the EU, I think that the new artificial intelligence regulations will not change dramatically. So we already know what kind of requirements are imposed on deployers and on providers of AI. However, it is quite clear that many of these requirements and obligations will be later subject to additional regulations, additional guidelines, additional requirements to be actually drafted by the European Commission. So I don't think that, taking into account current state of law, we would be able to really draft something in detail. It will be very difficult. It would be like, like GDPR requirements. At the point when GDPR was actually effective, everybody was asking everybody what does it mean, how to make it more specific, and several months had to pass before we knew this. So I think my general idea is that in order to include very general language, there must be a requirement to adapt later, a requirement to comply with future regulations, because I don't think that we are able to really regulate everything as it will be required by the law.
So for those of you who do contract drafting, which I don't do, so I'm the last person who should be talking about this, other than just asking questions. When your clients enter into 3-year contracts to obtain services that might use AI, either as part of the service or underlying the service, so it's got a long, well into the future, the services will be provided. Are there things that you're doing or think you should be doing to specify that the vendor, for example, is going to make their systems interoperable, or that they're going to disclose on their website how it works? Like, what level of detail do you get into?
Well, I think that, already now, these general ideas to be imposed by the new regulations are very general, but are quite understandable, like traceability, like transparency. So if you obtain a service like coding service, right, IT service, you can require from your provider to, first of all, to have access to source codes and to do a proper drafting of the source codes, because it requires certain specification, requires description of the source code. So if you are applying the current state of art in terms of coding, then you would be required, you would be able probably to comply with the requirements of transparency in the future. This would be my guess.
Other views?
It's interesting you raised that, because I think one of the challenges that is posed by this new generative AI is that the reproducibility of the responses or the answers is not quite on the same footing as where you might have, say, the more traditional way of coding stuff, which is where you would have source code that determines outcomes. All right. So if you were to just run this experiment, you ask ChatGPT a question in one session, and you ask ChatGPT the same question in another session, and you will get different answers. And sometimes you would also get a completely made up answer. And the reason for that, the scientists themselves, sometimes they're seemingly even at a loss as to explaining how it is that the answers are generated. It's because of the vastness of the data sets that they're using, and then the correlations that they're drawing as between the various tokenized concepts that are now in the system. So the traditional approach has to say, review of source code or the disclosure of source code, that's only going to address one part of it, which might be perhaps how is the engine constructed. But what about the data that the engine is working off in order to give you the answer? I think that's the big challenge that I think we as lawyers are going to have to also figure out the appropriate way of addressing.
Other views? I know we have some M&A lawyers here as well. I can tell you, like I said, I don't do an M&A, but in the last 3 months, I've had a spike in people asking for essentially what are risk assessments or second opinions. They're buying a company that has an M&A technology or deploys it in an important way. And I get asked, how much risk is the buyer taking or the lender taking? You know, is the business going to be compliant? Is it not going to be able to do the thing it's been doing using AI technologies? How much is it going to cost to get into compliance later on after the transaction's complete? Are other people sort of facing those kinds of questions in this environment of uncertainty? And I say all that, by the way, the questions almost inevitably are for companies that operate in many different jurisdictions. So it's not even like you can point to just one set of laws. On the M&A side, how are you dealing with those kinds of risks? Please, anybody who wants to go ahead.
This is Alain. I haven't come across any of these situations where the entity would be active or kind of this would be part of their business model to actually sell AI based tools. But I could imagine that many of those questions boil down to what was said beforehand, namely to data protection, privacy, compliance issues. That would be my first reaction to this issue.
So is that the, you know, the traditional, what they teach in law school, right? Break down the problem and try and see if it fits an existing box? Or are we
isn't it a bit like when we had internet, right? There was a question, oh, this is internet law. Well, what does that mean, right? At the end of the day, we noticed that the issues are very much the same, whether, I mean, we use it in internet or we use it in a traditional way. So I can see that the business model of AI, if you buy particularly an entity that has this in their business model to actually provide services, that could be a specific compliance issue to test on top, but it's nothing, at least I haven't seen any particular AI issue in there. It boils down to what Chung said beforehand.
Has anybody seen from their own clients AI requirements that are making their way into the engagement agreements they have with law firms? I only noticed because a very large German-based company recently sent me their new standard terms, and then a provision that said if you say use AI, you have to do so responsibly. That was their word. And we said, of course, we'll do that, despite the fact that I don't have a clue what that means.
Well, I've had a US client write to me recently saying that human oversight is critical and any work product generated must be reviewed for accuracy by a person working on the matter. So they've been very explicit about, you know, what their expectations are. And we have to make specific disclosures as well if we do make use of generative AI tools. So don't know, it'll be interesting to see whether, you know, anyone else might have similarly experienced client demands of this nature.
We had in Germany with an automotive client, but it was not so far detailed. It was rather the request for us, for it was a big litigation issue all over the world, handling their issues over the product compliance, product liability. And they have asked us to only participate if we can cover things with AI. But it is still in the process of negotiations there with the client. And in this process, we're dealing with what requirements they ask from us to take to deal with AI. But it was for them, for most, it was a matter of pricing, let's say. They wanted to deal with things in a very effective way.
What about limitation of liability terms? Like we've seen evolving terms where you have specific different limitations for confidentiality. IP is different. Sometimes you see data protection as a different cap. What about related to AI? Does anybody either have seen or think that we need special indemnities or caps related to AI?
This is Jeff. Like Alan, I just haven't seen it hitting agreements too much yet, but I think it's no doubt, around the corner. But I just haven't seen it coming through. I will just mention an interesting thing that happened yesterday. I had a Zoom call with a new client, and we got on the call. It's just me and the client, and there was a third participant that said something like AI read bot, and I asked, is that your colleague? And they said, no, this is just a new program that I'm using, and it records the call, and so it makes a transcript. And I said, okay. And literally about 5 minutes after we hung up, I received an email from this AI bot that had about a 4 or 5 paragraph summary of our call, a half-hour long call. It was incredibly accurate with takeaway action items from the call and everything else. So quite startling. I mean, I haven't even started to think about the privacy implications, frankly, of that type of use of AI, but I was quite interested to see it.
So Jeff, you would have, I think you joined the call a minute or two into it, so you may have missed Hannah's announcement that this call is being monitored by AI.
So will we receive a similar summary? I'm so excited.
We don't have it set up, Jeff. We don't have it set up to send the summaries to participants. The hosts receive them, however. And that is what I use for my note taking and sending the recaps. And it is fairly accurate. We do have a few challenges because we are a global organization, with some translation issues with various dialects and accents from around the world. And we do have to go back and, it'll get names wrong, or, lithium was translated 27 different ways in our energy call a couple of weeks ago, but it is actually pretty good at the summary and note taking. And I do try to announce that at the beginning of the call to say, we are recording this. You see my AI friend in the chat. She's recording this and taking notes for us. But we found it to be a pretty useful tool given the volume of meetings that we are doing. And of course, I've had people say, hey, can we not record this session today? And I just simply turn it off and don't record it.
Yeah, I would, if you are willing to share it, I would love to see the summary and to know which program you're using. Just curious if it's the same one.
It's called Otter, but yes, I will send you the summary, Jeff, so that you can see that. Yes.
Okay. Yeah, this one yesterday was not Otter. It was different and new to me. So anyways, I did use that.
On that point, again, it's more of a practice point. During the pandemic, when people do M&A deals, they often have these diligence calls that used to actually be phone calls where they weren't recorded. There were no slides. People took notes and went away. I'm in the midst of an arbitration. I'm actually going to hearing in 2 weeks where all the diligence was done during the pandemic. So it was all done by Zoom, and they recorded all those Zoom calls, which we were then able to feed into, as it turns out, Otter, the same AI system Hannah uses, to generate instant transcripts. So we actually know what people said during the diligence calls. So I wonder how people feel about systems like we're using on this call today being used during diligence, or is that just a huge mistake? For the people whose faces are on the screen, I can see what looks a little bit like terror. Views? Like, would you, when you're doing diligence on any kind of deal, do you think it's a good idea to not only call the calls, but generate instant transcripts?
So my own perspective is that, it's funny you should mention this, because I literally just got off a diligence call before joining this session. And the issue is this, right? If you do have just a recording of the call, without the transcript, then it's really difficult to pin down the specific representations that were made during the call. So at the end of the day, it's still really important. You know, the whole purpose of the diligence call is to record a whole bunch of representations that have been made in relation to transaction. So the recording per se is not going to be a really useful way in which you're going to be able to get hold of that information. You still need to get it reduced into writing and then, you know, made part and parcel of the contractual terms. But of course, from a litigation perspective, if things go wrong, and then of course, you know, the fact that these recordings exist, you know, you might then be finding, and of course, depending on which side of the line you're on as well, there might be some, you know, subsidiary information or nuances that might have made its way or survived that recording that might turn out to be very material in terms of taking a position later on. I guess, you know, the issue also arises, right, where you, Peter, with your with the disputes and arbitrations and mediation types of proceedings having moved on into Zoom platforms during COVID, the kinds of experiences and even the rules that evolved around the fact that that you were using these kinds of virtual hearing technologies right now. Rules evolved around, you know, turning off your virtual backgrounds and all, just to make sure that there is the security and confidentiality maintained of your hearings.
Other thoughts? So, sorry, go ahead.
Yeah, I was gonna say, like, to me, in terms of just the recording and then the summaries, that it doesn't really seem that new to me. Voice to text has been around for a very long time, and so creating transcripts from calls that were just audio, that you recorded the audio or something like that, has kind of been around. And then the second step, I guess, is generating summaries, which again isn't really that much different. It just makes it faster to me than you know. So I don't really have any feelings, negative feelings about diligence calls, whatever, what have you, that are being tracked by a program like Otter AI or anything like that. To me, it just kind of seems like less steps to accomplish the same thing you could have been doing before.
Well, I tend to agree on the transcript side, but the video is a bit of a game changer. I can tell you at the hearing I'm having in 2 weeks, I plan on playing clips of the lead person on the other side, who on the video, you can see them on their phone, paying no attention hour after hour. And so when they complain they weren't told certain things, it's not going to look very good. It's a little bit of theater there, obviously, that you don't get to do on the old way. Can we just talk about high impact systems for a minute? Because a lot of the AI laws that are either in draft or going ahead, including the European model and the Canadian model, have different rules for systems that deal with areas of sensitivity. The wording that's used differs around the world. But if you have a client who's either selling or contracting to use these kinds of high impact systems, are there particular wordings you want to put in the agreement for compliance? For example, like, how are you going to do audits to figure out whether they're doing whatever it is properly? You know, what record keeping are you going to require those suppliers to have? How are you going to make sure that whatever the high impact is, it's no more than necessary to provide whatever the service is? Like, are you thinking that all these things should be specified in detail so that if you do have a high impact system, it's kept in a box, if I can put it that way? It doesn't increase the risk beyond where it needs to be. Any thoughts? Or maybe what somebody said about GDPR is the right model, which is that we're sort of just before GDPR. We're in that time frame, and people don't know what to do.
Well, in some cases, when you're talking about some of these high impact systems, so we have, for example, critical information infrastructures. Once that's designated, the regulator actually steps in and they demand for the owner of the system to provide kind of a network architecture that must be disclosed to the regulator. And the law then has a reach into interconnected systems with the regulated infrastructure. So again, you know, that's if you're going to be plugging a system to a critical information infrastructure, your contractual positions need to kind of deal with that kind of regulatory oversight as well.
Thanks, Chung. As we come up to the top of the hour, maybe we can just take 2 minutes at the end to do two things. One is, it strikes me that something this group may be able to do that would be massively valuable for our firms is to come up with a due diligence checklist for deals that involve AI. So like, what questions to ask? And it may be that that list is a little bit different from M&A than commercial deals. But I don't know what you're seeing, but my colleagues who do this work, you know, are now dealing with not just acquisitions of AI companies, but companies that use AI in an important way. And because it's also multi-jurisdictional, do people have a view that maybe it would be worth making a little subcommittee to work on a diligence checklist that we could sort of combine and circulate to our firms that would be a useful tool? What do you think? So there's some nodding, not everybody's on screen, but maybe Hannah, you can send out a follow-up email that just asks for volunteers. And it's always dangerous to ask for volunteers after a call because everybody goes back to their busy day. But I think this is something actually that may be not a lot of work to do, but would give a few of us an opportunity to collaborate in a meaningful way and actually turn out a work product that would be really helpful to the rest of the people we practice with, and can, you know, have the security of knowing that a lot of smart people have looked at it. So for those of you who are interested and want to put your names on it, and obviously that would get your name around among the World Law Group, if you could send Hannah an email after this call, sort of putting your hands up to volunteer, I think that'd be really helpful. And generate something that we can maybe come back to the group once there's a draft and everybody could add their thoughts. But we do need a few people to take the first cut at this. And then the second thing is, I think I mentioned that I'm the president of iTech Law. I don't know how many of you are going to the conference in a couple of weeks in Amsterdam, the European conference. But again, if you let me or Hannah know you're going to be there, I would love to get together with you in person. This is probably, you know, my 15 minutes of fame. So I probably actually have the only power I have is to find a room for us to meet in, or a table at breakfast or something. So I'd be happy to do that and see if we can get together there.
And can I also ask, in the same vein, anyone attending the IBA meeting at the end of the month? Because I will be there, and then, you know, it'd be a great opportunity to meet up with any of you who also be attending.
I do see a couple of folks on this call that have indicated on the website they're attending iTech Law. But if there are others of you, please feel free to email me, and I'll circulate that list around. And then regarding IBA, I know that we have a very large number of World Law Group attendees at the IBA. So let me know about that too, and we can add you to the list. And again, I circulate that and I indicate everyone's practice group areas on that list when I circulate it, since it is very wide ranging. And we do have, I mean, I think last year, I think we had close to 150 World Law Group folks who attended IBA. But it's a great place for you guys to get together and meet in person.
Okay, well, with that, thank you all for joining us. Thank you, Chung, for your initial presentation. That's great. And I'm looking forward to meeting as many of you in person or at our next call.
Yes, and before we let everyone go, I will mention we are doing WLG at large this year, which is the first week of December. And one of the sessions will be focused on AI in the employment sphere, and that will be happening on the Monday, December 4th, I believe. So stay tuned for more information on that session and that program for the week.